I need a will if I'm in a common law marriage? My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota and New York City. And today we're going to talk about, can you inherit from your spouse if you're in a common law marriage? Now, you'd probably be surprised how often this question comes up. These days, a lot of people are living together and are not getting married. And what happens is, after you've lived together long enough, you may consider yourself to be a married couple. And whether you've seen it in films or read about it somewhere, a lot of times people will contact me and say, well, I don't have to worry too much because I'm in a common law marriage, so if something happens to me, my common law spouse will inherit what I get. And unfortunately, I have to tell them if they're coming to work with me, the answer to that's going to be no. The reason is that the states where I practice law, where I do estate planning, none of those states recognize a common law marriage. So before you tell everyone you're in a common law marriage and that you've got your estate planning all in line because of that common law marriage, take a step back and first of all figure out whether you truly are in a common law marriage. So to shoot this video, I had to look up real quick what states actually recognize common law marriage. Because it's one of those things, again, you hear about them in films and TV shows and people talk about them, but the reality is there's a very small number of states that actually recognize common law marriage. So when I looked it up, we have the District of Columbia, Colorado, Iowa, Kansas, Montana, Oklahoma, Rhode Island, South Carolina, Texas, and Utah. And one caveat to this is that apparently if you're in New Hampshire, they will actually recognize a common law marriage solely for the purposes of probating an estate plan. But of course, as I said, I don't practice in any of those states. So if someone comes to me in the states where I practice, which is Minnesota, New York, New Jersey, Connecticut, and they tell me they're in a common law marriage, so they don't need to worry about estate planning, I have to unfortunately tell them that if you're living in those states, you're not in a common law marriage. Maybe if you lived in one of those prior states, the ones that actually recognize it, that was an idea that you could go with. But if you're in the states where I practice law, there is no common law marriage. So once we get past that fact, and people are a little upset to realize they're not actually in a common law marriage, the next question is, so what do we do now? If I'm not in a common law marriage and something happens to me, what happens to my assets? Of course, I tell them, well, you're treated like anybody else who's single. You're not married. You can be living with somebody. You can own property together. There's lots of estate planning tools that maybe you have beneficiary designations on your accounts. You own a house together. You own vehicles together. There's lots of ways that you two living together can provide for inheritance of certain assets. However, you don't have the same rights as a spouse would have. And if you want to make sure that your partner is provided with everything that you intend to leave them with an estate plan, leaving them with a legacy, especially if you two have children together, you need to create an estate plan. So what kind of documents can we use if we have folks who thought they were in a common law marriage but are just living together and we want to make sure that they're getting their estate plan correct? First thing is a will or a trust. So depending upon what your assets look like and what your goals are, we can either create a will or a trust. And those documents can make sure we're providing for your partner, who is not your common law spouse, and make sure it's providing for your children. So if you have children together, we want a guardianship provision and probably a trustees provision, so that if something happens to both of you and those children are under the age of 18, we know that their legacy is protected. Next, and especially important in these situations, is a power of attorney, both a healthcare power of attorney and a financial power of attorney. If you're not actually married, the doctor is not required to consult with you when your partner gets sick. So if they're in the hospital and they're sick and you say, wait a second, that's my partner, I want to be in here making these medical decisions, the doctor's not required to. They can say, well, you're not the spouse, so we're not legally obligated to speak with you about this. Same thing with your finances. If you become sick and somebody needs to manage your personal finances, that power of attorney will allow your partner to be able to do it because they don't have that legal right if they're not your spouse. You also want to look at your healthcare directives along with the healthcare power of attorney, your HIPAA authorization, and a living will. You want these documents to spell out that this is your partner and you want them to make these important decisions. If you're concerned about other type of rights between the two of you, you can look at what's called a cohabitation agreement. So it's not really a prenuptial or postnuptial agreement, but it's an agreement between the two of you that takes care of what happens if, unfortunately, you two split up and we have property together and we have children together. A cohabitation agreement can spell out the rights that you can expect to receive at the time of a breakup. And then finally, we talked about a little bit before, but the beneficiary designations on your financial accounts. Now, your spouse gets actually tax benefits from being able to receive your retirement accounts through a beneficiary designation. If your partner is not your spouse, they don't receive those same tax benefits. However, it's still important to include them in the plan. And if you want them to be the primary beneficiary, work with your financial advisor to make sure that they are listed as your primary financial beneficiary. So when we're looking at these kinds of plans, there's always two ways to do them. The first way is to try to do it yourself. Unfortunately, when a lot of people come to me and say, I'm in a common law marriage, I don't need to worry about that, I've been doing this all myself, it's when I have to break the bad news that chances are if you're in one of the states where I'm practicing law, you don't have a common law marriage, and what you've been trying to do yourself may not be accomplishing your goals. So the second way to do it, the smarter way to do it, is work with professionals. Talk to your financial advisor. Make sure that you understand the implications of how you're leaving money to your partner in the case of your death. Talk to your accountant. Make sure you understand with your accountant what the tax implications are going to be for you and your partner if something happens to you, and even on an ongoing basis. Does it make more sense for you two to get married at some point? Would you get additional tax benefits? And then when we're looking at the estate plan, talk to your attorney. If you don't have any estate plan in place and you're living in a state without common law marriage, you can't just rely on the fact that you hope everyone will give something to your partner when you're gone. If you have a bunch of siblings and you don't have any children, chances are the siblings, not your partner, are going to be the ones who inherit under your local rules. So if you'd like to get started, you can give my office a call. You can go to andrewmayers.com. There's a little red legal strategy session button on the main page. Click that, you'll be taken to my personal calendar. We can set up a 15 or 20 minute legal strategy session to discuss where you are in the process and whether or not you have a common law marriage. And if you don't have any estate planning documents in place, we can give you some next steps and some best options for you to protect you and your partner. So while you may think you're in a common law marriage, unless you're in that list of states that I provided for you, you're probably not in a common law marriage.